Hi, we're back discussing some of the possible ethical issues that arise in family law. Conflict of interest is another one. It can take the form in many ways. Multiple representation, trying to represent multiple parties in part of a lawsuit or a divorce. Might be say there it's a friendly divorce, but you never know. You can't really do both. Former client, present adversary. That's a conflict of interest. So say the husband was a client at one time or something, a contract or real estate deal. And now the wife has come to you and asked to be her attorney with her husband being the adversary. Can't do it. Sometimes the whole law firm can be disqualified um, because of all the relations it might have had with one of the parties. Identity of the client. You can't really even tell somebody that such and such is your client. um, Business transactions with a client. Don't be in business with someone you're representing as your client. Gifts from a client. You can't really accept gifts from a client. There are some exceptions, and people do it. Don't loan money to a client. Um, you can pay for some expenses that might be related to a lawsuit, but that's it. Sex with the client. Yeah, don't do that. And bias. What's multiple representation? Attorney representing husband and wife in a so-called friendly divorce. It's usually unethical and against the law. Some states allow it, but you still shouldn't do it. It's just because you never know when a friendly divorce is going to turn unfriendly. Safekeeping of client property. You have to keep the property safe, meaning the client funds must not be placed in the same account with office operational funds. Commingling is what that is. Don't do it. Anti-contact rule, as explained earlier, an opponent must not be contacted without the permission of the opponent's attorney. So you can't just contact the soon-to-be ex-wife. You have to contact the soon-to-be ex-wife's attorney. The opponent is unrepresented. He or she must not be led to believe that you are disinterested. You have to clearly identify who you're working for. The only advice the opponent can be given is to obtain his or her own attorney. False evidence and statements. Attorneys must not knowingly offer false evidence or make false statements. They have an ethical obligation to be truthful in court. And if it's later discovered that material statement in court that they now realize was false, they must correct the statement in court. So your witness went on the witness stand and lied. The attorney has to tell the court that their client was lying. Um, and this is one that is hard to do. But say you're arguing a case, and you know that there's a case or a law that would contradict the position you're taking, and your opposite side doesn't pick up on it. You still have a duty to tell the court about the other issue. Then you work on differentiating the two. But you can't let, if there's a court decision out there that the other side doesn't pick up and it would be in their favor, and they don't mention it, you have to bring it up somehow and then differentiate yours from it. It is unethical to use deception or to misrepresent or fail to disclose your identity online, e.g., Facebook, in order to try to obtain relevant facts on a legal matter. Don't make up a fake name and then try to Facebook friend the person your client is getting divorced from. Just trying to get up dirt. Don't do that. Notarization, as I said earlier, the notary must personally observe with their own eyes a person sign a document before notarizing the signature. Solicitation, in-person, live, telephone, or real-time electronic solicitation of clients is unethical if the attorney's goal is to seek fees or other financial benefit, unless the contact is with another attorney. So, or someone with whom the attorney has a family, close personal, or prior professional relationship with. So, in some cases they can do it, but you really can't go, cold calling. Or you see that there's been an accident and you call and say, hey, I will represent you. Can't do that. It's ethical as long as the attorney knows that the prospective client does not want to be solicited. And the solicitation involves coercion, duress, or harassment, or the solicitation is untruthful or misleading. A paralegal who receives inadequate attorney supervision is engaging in the unauthorized practice of law. It is really the attorney's job and responsibility to oversee the work of their paralegals. Self-help and unauthorized practice of law. And I think we covered this, a case like this in legal ethics. There are places where you can get legal forms, and those are considered non-attorney freelancers. But they can't give legal advice, select the forms for the client, or advise the client on how to fill out the forms. So they come in and ask for a form, you can give it to them. They can't describe a situation, and then you tell them which form they need. That's legal advice. The computer company can sell self-help forms that a buyer can fill out online. If, however, the company has human interaction with the buyer by making corrections and suggestions based on the answers provided, it might be EPL. And in Louisiana, be very careful of these because a lot of these forms don't meet Louisiana requirements. And this is the big one. It's so tempting when someone you know and care about comes to you with a legal problem and want your advice. Because you want to help them. They're your friend or your family member, but you can't do it. It can come back and bite you. Even if you're certain that the legal advice is accurate, you can't do it. It's a legal advice is a statement or conclusion that applies the law or legal principles to the facts of a particular person's legal problem in an attempt to help resolve that problem. So you could describe a case, but you can't say how it's related to them. And I would just avoid doing it in any case. You want to direct them to an attorney or to someplace where they can get legal advice. You can't be there. You just really, because okay, this is the reality. You've given advice on other issues to people, and they may follow part of it. And then but they don't do everything you said to do. And then they come back and say, well, I did what you told me to. And somehow it's your fault for them not following your advice exactly. So you really want to be able to stay clear of that because you can be sued in an unauthorized practice of law situation. Okay, that's it for this chapter, and good luck. And I'm going to ask you to write your reflections on this video and the last video for chapter 2. Let me know what you learned, didn't learn, found confusing, or whatever. Thank you.